Hi, my name is Dave Gloria, and this is my Kinesiology 550 Legal Issues in Kinesiology critical assignment. I have chosen the athletic training facility or program as my subject matter, as I currently work as director of sports medicine at a small private high school in Southern California. Our first topic will be risk management, and our first case will deal with sexual harassment. In the state of Illinois versus Williams-Watson, Felicia Williams-Watson, a certified athletic trainer, was charged with 4 counts of criminal sexual assault and 2 counts of aggravated criminal sexual abuse at the school she worked for, Massac County High School. Now, when we hear a case in the magnitude of this case, where do we begin with mitigation? Where does the process start? And through studying and through research, one word kept coming to the forefront, and that was awareness. We can't necessarily prevent things like this from happening, as it was noted in the case that Felicia Williams-Watson had every intent on having a sexual relationship with 2 students. So this is not something she did by accident. So some things, unfortunately, we cannot prevent. But what can we do for the individuals in our program, the students, the interns? What can we do for them as they are going through this process? And sound harassment training within every athletic training education program is a must. Creative, effective training programs that emphasize knowledge, perception of sexual harassment, and standard reporting procedures is a must in every athletic training education program. We need to create, as administrators and directors, we need to create a safe haven for everyone working within our program, whether a student, whether an intern, or whether an athletic trainer. And we need to provide a place and a space where they can come and feel comfortable if they've been the victim of sexual harassment, or if they know of someone who's been a victim of sexual harassment. We need to provide these trainings and these places, these safe havens, for these individuals to come to, so that we can bring these things to light and deal with them in a professional and an efficient manner as soon as possible. Our next case is Rios versus Grossmont Union High School District, and this deals with negligence. And in this case, a college student athletic trainer was called upon by a head athletic trainer to cover a football game in the state of California. The head athletic trainer was not going to be present, needed someone to cover the game, called someone he knew who happened to be in college in an athletic training program, and this individual agreed to do it. During the game, there was an injury to one of the athletes. The athlete came and was assessed and evaluated by this college student athletic trainer. He was okayed to play back in the game, and unfortunately and tragically, this same athlete suffered an even more severe injury, which was a fracture of one of the cervical vertebrae. This required immediate transport and immediate surgery, which ultimately ended this individual's high school playing days. The mother, brought up a lawsuit and stated that under the National Athletic Trainers Association recommendations and guidelines, that a college student athletic trainer should have never been allowed to cover this game, and that the school was at fault for allowing this individual to oversee the game. As the CAA-TE states, students to be under the supervision of a credentialed healthcare provider at all times when providing patient care, and that they not act as a replacement for appropriately credentialed staff. Now, this mother would have every leg to stand on in this case, except that this happened in California. California does not regulate the licensure of athletic trainers, and this means that anyone can claim to be an athletic trainer. Any administrator can take someone off the street and ask them to cover a football game and assume the responsibility of an athletic trainer, even though they may know nothing about it. And so what the school said is that we're not under the NATA because California isn't regulated for athletic trainers. So we don't fall under the NATA. Therefore, we're not liable for what happened. And unfortunately, this was true. The courts sided for the school, and this was just a tragic scene altogether. So how do we mitigate something like this? And me being working in Southern California or in the state of California, this is very important. And the ways to mitigate something like this, in my personal opinion, is for administrators to hire a certified athletic trainer. Don't hire someone you know or someone who has limited knowledge because things of this nature could happen. I would encourage administrators to know the standards of the Board of Certification. Know the complexities of what it takes to be an athletic trainer before you make a decision to just hire someone off the street or hire someone with limited knowledge. So that would be one of my first strategies to mitigate something like this. Next is communication liability. In the case of Searless versus Trustees of St. Joseph's College, a freshman basketball player during his freshman year went to the athletic trainer complaining of bilateral knee pain. The athletic trainer assessed and treated this individual and told him that he should not continue to play for a few weeks while undergoing treatment and rehabilitation. However, this information was not professionally documented, and it was not relayed to the head coach of the basketball team. The basketball coach, since he never got this information firsthand, continued to play and pressed Searless to play. Searless continued to play, and by mid-sophomore year, he had to quit the team and get bilateral knee surgery, which ended his playing days. And in this case, the court found that the athletic trainer and basketball coach were both liable and negligent in this case because there was not professional and clear written documentation and communication of what needed to happen with this athlete. So how do we mitigate something like this? Well, to me, it's more common sense than anything else. Athletic directors, coaches, and athletic trainers, they all need policies and procedures. Whatever those policies and procedures are as it pertains to an injured athlete, and the communication between the coach and the athletic trainer and the athlete all need to be on the same page. If an athletic trainer says this athlete is going to take this amount of time off, then that athlete's going to take this amount of time off, and no coach should have the right to press a player to play against that. However, because there wasn't clear documentation, there wasn't clear communication between the coach and the athletic trainer, this unfortunate case happened. So we need to mitigate that much better and make sure there are policies and procedures set in place so that these type of incidents do not happen. Moving on to employment law, sex discrimination. Yakovich versus Mount Pleasant Area School District. Yakovich was an athletic trainer for a high school for 20 years, and she was also a member of the school board of that high school. When she was relieved of her duties as an athletic trainer, she retained her standing on the school board. She was later hired at a private firm corporation, and the school that had relieved her of her duties as an athletic trainer were considering hiring her back. However, when they found out that she was working at a corporation, at this private corporation, they found it to be a conflict of interest to rehire her back for the school, for whatever reasons, for their reasons. However, Yakovich did find out that the man that they hired to replace her not only was on the school board that she was, but that he also worked at this private firm that had just hired her. So she brought up a lawsuit and said that this is sex discrimination. And ultimately, the courts found cause of violations against discriminatory laws. She was awarded a very large sum of money, and the question is, how do we mitigate this? And mitigation strategies should be relatively uncomplicated in something like this. It's basically to know the law. Know the laws, know employment law, know the state regulations that are out there. Really heed counsel if needed before firing and rehiring, and make sure that we are not doing something out of the scope of the law that could land us in trouble. So it's really knowing the law, doing our homework, and seeking counsel if needed when it comes to firing and rehiring. Disability discrimination. In the case with Kerr versus Drake University, The athletic trainer was fired for urinating in a whirlpool when he was witnessed by another staff member. Kerr, the athletic trainer, stated that he urinated in the whirlpool because of a medical condition, an existing medical condition, that was due to a enlarged prostate, which required him to drink lots of fluids during the day, which in turn resulted in him urinating more frequently during the day. And this is why he urinated in that whirlpool. And while the athletic director was sympathetic to his condition, she stated that this athletic trainer never disclosed this information to her out of all the years that he worked there. There had never been an incident like this that she had ever known. And so ultimately, the courts were okay with her terminating this man, basically because he never disclosed it to them. Now, what can we do? How do we mitigate something like this? And again, it seems like just common sense, but we need to know the people we work for. We need to know them before we even interview them. We need to screen them very well. We need to vet all of our applicants very well. And then if we do hire someone with a disability, we need to accommodate that disability. We need to give them reasonable accommodations so that they are able to perform their job at the level of expectation that is expected of them. So that is one of the first ways we would begin to mitigate, knowing who we're hiring, know who is working with us, so that we can accommodate any such disability that they may have. And the last case is age discrimination, Moore versus the University of Notre Dame. One of the coaches on the University of Notre Dame football team alleged that he was fired because the coach claimed that he was too old. And while the head coach said it was not because of his age, but because of this other coach not holding to the standards of the university, Moore, the plaintiff, brought a lawsuit against the school. The school ultimately sided with the university in not having to reinstate Moore back to his job, but they did award Moore front pay. And again, so money did have to be taken out of the university to award the plaintiff his verdict. So how do we begin mitigating something like this? If there's ever a question of not hiring someone because of their age, whether they're too old or whether they're too young, we need to really look into that. We need to set up a business necessity defense as well. And basically what that is job requirement connected to job performance. So if there is something in play that needs to be done, and a certain individual who is being considered to hire cannot perform that duty, and we choose not to hire them, it's not because of their age, it's because they could not perform what they needed to perform in connection with the job requirements. So as an administrator, we need to have these business necessity defenses in place so that we would never be accused of age discrimination. My future career plans, what am I taking away from this course is preparedness, is knowing the laws, or knowing the state regulations, going over all of those things again, and really meeting with my staff and my coaches and my athletic director. And this is something I plan to do, is go over each and every one of these cases with them so that we can just better prepare ourselves and educate ourselves with the things that we need to do. My faith integration is John 13, 14, 15. And since I, your Lord and teacher, have washed your feet, you ought to wash each other's feet. I have given you an example to follow. Do as I have done to you. This is servant leadership. If I'm a leader, I need to serve every single person next to me, below me, and above me. Jesus said, this is the example I give to you. Do as I have done to you. Romans 12:18. If it is possible, as far as it depends on you, live at peace with everyone. In our working relationships, it is dependent on the Christ followers to be at peace with those we work at. And I think that is super important for a healthy relationship with those that we are working with on a day-to-day basis. And finally, 1 Peter 2:13, 14. For the Lord's sake, submit to all human authority, whether the king as head of state or the officials he has appointed. We need to follow the laws, the state regulation, the employment laws. We need to know them, and we need to adhere to them. It's in the Word of God. That is my assignment. Thank you, and God bless.